Haven't made a case. Is that the
Well,
truth?
you know, the truth is, we were the ones that got sued. The complete burden was on Mr. Davis today to show the court that what he's proved is something that's contrary to the Alabama law, that the party did something. There's absolutely no question that the party has a rule. We call it the Radney Rule. Whether people like the rule or not, it's the rule. And if you're ineligible for the rule, you heard my little short cross-examination. The only reason we're here is because he lost the vote on the exemption to the Radney Rule. So he's trying to get the court to put its judgment and say, look, I would have been a great candidate. I can't understand why they didn't let me do that. I mean, that's it. And the Democratic Executive Board, it came out today, we heard this, he was supposed to get 2/3 of the vote. He had 1 vote out of 24 people present. They made that decision. You can't take the court's position or what he thinks and substitute it for all the individuals here. You know, the people that he called as witnesses today, they all heard him. They all said, man, you know, you didn't do your job. You didn't persuade us. You didn't show us that. We never heard anything contrary. There hadn't been a single person. He could have subpoenaed anybody, and he did. He subpoenaed representatives. He subpoenaed people that weren't even here. Nobody said the party did something wrong. Nobody said the party did something contrary to the rule. The case that we are relying on was a Republican Party disqualification, and the Supreme Court said that that person wasn't allowed on the ballot, and they didn't even let that person have a hearing. We gave him a hearing. He talked for over an hour, and you saw him today. He kind of talked his way out of it if he was going to have that happen.
Now, you were there at the hearing. Davis offered that statement today. Was that statement a representation of how he sounded at the hearing?
It was a little, you know, he read from the statement a little while, and then he went. But it was up to the party. I mean, the people that were there. And I was there as the attorney. I wasn't there voting, but the burden was on him. The party rule says preponderance of the evidence that you would be an asset to the party. And it's a judgment call they made. These people didn't think so. And so, yeah, you heard the testimony today where he was telling them, you have to let me do this. You know, it's somebody else. It's like, well, officer, I know I was going 80 miles an hour, but you missed the other car that went by. You know, and that it's a sour grapes. It's a sour thing. Nobody has a right to run under a party emblem. Parties have certain rules that you have to follow by. If he wants to run for county commission, nobody's keeping him from running as an independent. We're just saying you can't run as a Democrat this time. Nobody's keeping him from voting as a Democrat. Nobody's keeping him from being a Democrat. We just have rules about if you're going to be our candidate, just like the Republican Party does.
Why does he not have a good point in the fact that he was treated differently than Parker Griffith, even though Parker Griffith, you know, ran as a Republican, voted against Obamacare? And
you know, it's sort of like, you know, I try cases, and you got a fact situation that's similar. One jury might find one time this, another jury might find that. And it's a different fact situation. I don't know what all Parker Griffin did politically behind the scenes to say he was sorry and to be sincere about it. You heard the people that testified today that were on the committee, they felt like he didn't carry his burden. There was nothing like, I got told to do something or I was forced to do something. That didn't happen at all. And it's a value judgment that the party makes about who's going to be on their ticket. Now, if he can show and he stays loyal to the party, there's nothing to prevent him from running in the next election cycle.
The judge said, let you know soon. Any idea when we're going to...
I think the judge, in fact, at the end, I asked the judge, I said, Judge, I just want to show a case to you. And he named a case. I said, that's the one. So he's read it. It's the McGinley case that the Republican Party had where the court said, look, in that case, the Republican Party had a rule that said you just have to be loyal to the party. And they said, we don't want you on our ticket. And the court said, that's up to the party to do that. We can't substitute the court's opinion about something for the political party's opinion.
What year was that, like 2004?
2004. And it's been the law, it's still the law. I mean, the statutes in Alabama allow parties to put more burdens on something. If we wanted to say you had to have a mohawk haircut to run, we could do that. That might not be the smart thing. I probably couldn't qualify. I don't have enough hair. But that would be something that we could do. We could have that. So he's apparently upset that he lost his vote. You heard him say that today. And I will say, I told some of y'all, I've been practicing law 36 years. I've always wanted to stop and say if it was a fight, they'd stop it. In his examination of Representative Holmes was something that I didn't know what to do or say. It was pretty good.
Do you think that their witnesses worked more in your benefit than theirs?
I think absolutely. Every one of them kind of substantiated that he didn't carry his burden with the party. But what we had to do then, well, he should have done back when we had this meeting. He should have worked people and called them and said, look, I'm going to be an asset to the party. I need you. I want to run. Now, he's somebody that, he stood up there when he testified and said, well, it's because I came out against Obama. Of course, I had to remind him that he was getting money from the Montgomery Republican Party as late as last year. So there was a matter of trust here about how long somebody, what have you got to do to gain the party's trust? And it was a value judgment of those 24 people.
So, I mean, correct me if I'm wrong, pretty much doesn't matter what you do before the hearing, you're already in violation of the Radney Rule. When you seek the waiver, at that point, it's all about how you come across.
Right, and he was kind of in a catch-22 situation because he's admitted he violated the Radney Rule. That's why he wrote the letter. He said, I knew, and that's what he says in the letter to Chairman Worley. But now he's saying, well, to get me exempt from this rule, I don't like what you did. I should have won the vote. How could you not vote for me? That's what I heard today. And that's what we heard the other day.